Hello, everyone. Thank you so much for joining us for part 5 of our 6-part series, How to Build Value in Your Security Business. I'm Chelsea Davis, Channel Partner Program Manager here at Alibi Security. We have an exciting session today and in a bit of a different format than our previous sessions if you've been here with us the past couple of weeks. Led not only by Kelly this time, but also attorney Mark Katz is joining us as well for contracts, licenses, and legal readiness with Ask an Attorney Q&A. Super excited for this one, and Kelly and Mark have agreed to extend this session to 45 minutes to make some extra time for audience Q&A. But if you have to drop after the 30-minute mark, we'll make sure you get the recording and you won't miss any content there. If you have a question that you'd like Mark or Kelly to answer, just drop it in the Q&A section of the chat. That's where I'll be monitoring to field any questions that come in. And Kelly, I'll hand it over to you to kick us off.
All right, great. Thanks, Chelsea. I go through this every time where my Zoom button is in the way and I can't move my slides. There we go. Okay. So as Chelsea said, we are on part 5 of our series. These are going by so quickly. So I'm excited. I've had several people say that they've been on every one and they're getting good information. So thank you for spending your time. And thanks again to Alibi. You're really going above and beyond providing the education to your dealers, and this Value Builder series, I think, is one more of those ways that you are setting yourselves apart as a program and a resource for your partners. So thank you for doing that. So as Chelsea said, we are going to talk about some things today that may not seem like the most exciting topics, but they are definitely extremely important. I'm very thankful to have my friend Mark Katz with me today. Mark and his firm close more transactions in the security industry than any other legal firm that I know of. I am fortunate to get to work with them a lot. I am very proud of the work that we get to do together. They are an amazing resource. Mark, remind me, how many attorneys do you have in the firm now?
Currently, we have 7 attorneys in the firm, and we should be at 8 attorneys by the first quarter of next year.
Okay, great. So, and because they focus on our industry, they know the speak. They know what the problems are that potentially are going to come up. And they are able to prepare both buyers and sellers in advance of transactions occurring. So I'm really pleased to have Mark with me today. So I'm actually going to stop sharing and we will just start chatting. But Mark, first, will you please just share a little bit about yourself, tell about your time in the industry?
Certainly. Good morning, everyone, first of all. I have been in the industry for just over 40 years. I was in-house with National Guardian, Wells Fargo, SecurityLink from Ameritech, and Best Access. In all of those, we did hundreds of acquisitions. And when we sold Best Access in 2003, I opened the office originally. It was just me. And we've now grown, as Kelly asked, to 7 lawyers. We are a corporate boutique. We only do corporate work. And of that, 95% of that is doing transactions in the security-related field. We also do credit agreements for our clients with some of the industry banks. And so we can take everything our preference is to take these transactions, as Kelly knows, from the beginning to the end, cradle to grave, from the time a letter of intent is signed to sending you your closing documents. And we are located in Indianapolis, and we do transactions all over the country.
Great. So what we are going to dig into first is specifically about contracts. Mark will tell you, and we'll share a couple of stories with you about the importance of your forms. And really, this is your bread and butter. This is your, block of gold in your business, because without this, without the proper forms, with the proper language in them, you can put yourself at a lot of risk. And you also may be minimizing your overall value. So we are going to start out by just talking about, Mark, general idea of what any integrator or a standard alarm business owner should include in their contracts, what you're looking for, what are the important elements of it, and then I'll ask you some more specific questions after you go through that.
Sure. I think the first thing is read your contracts. Know what your contracts say. So often we'll start working with someone in an acquisition and say, well, tell us about your contract. And they haven't looked at it. They may have drafted it or purchased it a number of years ago and aren't sure. The really important components there, and it's slightly different if you're an integrator versus if you're doing monitoring on the alarm side, is if you're doing monitoring, you want to make certain you have a limitation of liability, limiting it to something, and I'll come back to that as to how that can hurt you. You want to make sure a third-party indemnity. Perfect example there is you're installing some type of system, and it could be an access system, it could be a fire system in a multi-tenant building, and somehow the system doesn't function properly and there's a loss. Either someone gets in the building and injures someone, building burns down. You want to make sure you've got a third-party indemnity because you don't want to get claims from 52 tenants and suddenly you're defending them, not the owner of the building, which is where the liability should sit. You want to make sure that you have the right to raise it. You want to make sure you have a term if you're doing monitoring. If you're just doing installation, it's slightly different, but if you're doing monitoring or ongoing maintenance or inspections, you want to make sure you have a term, be it 5 years, be it 3 years. And the second part of the term is you want to make really sure that there is what's called the evergreen clause, meaning it never expires. It's so at the end of the 1 year or the 5 years, it automatically renews either for like terms or alternatively 30 days. You were seeing more and more, especially on the residential and small commercial side, renewals of 30 days, because on the resi side, there are a lot of states that are putting that 30-day rule in there. If you do any residential, there's a federal and state law in most states called the 3-day right of rescission, where the client has the ability to cancel the contract 3 days after they've entered into it, and you have to return the money. There's language that should go on the bottom of your contract, but what a lot of people miss, there needs to be a separate 3-day right of rescission, a leave behind with the client, that if the client is going to cancel, they need to be able to send that form in to be able to cancel. And we didn't, a lot of times lenders weren't worried about that, but some of the lenders out there are starting to worry about that. I mean, you're never going to put the genie back in the bottle, and I think your risk there is low, but lenders are getting a little picky on that. As I said, a right to increase is something you want to have the ability to do. And then there are a lot of other clauses you should have in there, but those are the ones that, oh, the assignment, that's the other one you need to be careful of. You want to make sure that it's either silent on assignment with respect to the alarm company, or you want to make sure you specifically have the right to assign it, either subcontract your monitoring or assign it if you go to sell. As to the customer, you can make that the customer can't assign the contract without the alarm company's permission. But there are some horror stories, which I will tell you of one shortly, where the assignment clause was a big deal.
Yeah, for sure. That is the first thing we really look for, is to make sure that we're not going to have an issue with assignment. So, I'm going to ask you the next couple of questions are questions that came directly to me when people were registering for the webinar. So the first one is, do I need a separate contract that includes language about gun detection?
This is a new area, and I have not seen a separate contract, but you certainly can have a separate contract. And the trend in the industry is to try and do an all-in-one contract. And the reason for that, and that's been for a number of years now, and the logic behind it is that you don't want your sales rep grabbing the wrong contract and signing somebody up for a service that's not on that contract, and then it really doesn't fit. And your terms and conditions may be different. If you are using an all-in-one contract, just make sure that your sales reps are checking the proper boxes. A lot of times sales reps have the ability to bind the company. There are also some companies out there that will add a separate line on the contract where it has to be accepted by a manager or an officer of the company. And that's there for a purpose. The purpose is to make certain that the contract has been done properly. So you've got to be very, very careful in that situation, what you're doing. I think you can do it either way. You just need to make sure that if you are offering something like gun protection, or detection rather, or video or fire inspections, that the contract properly describes what you're doing.
So, kind of the same question. It came in slightly differently, but this is on remote video monitoring, which is a new hot topic. We talked about this a couple of weeks ago in our last webinar about this being such an awesome opportunity, both for business owners and for end users that are also business owners in many cases. But that is a different. It's different than just offering video. This is, somebody detecting things remotely and, and acting on that. So what is your experience on contracts for that?
It sort of falls in the same area, making certain that you're describing the service properly and you have a limitation. Where this gets in really interesting is the movable trailers, where they're on construction sites and then they move. Well, you've got to be very, very careful. If you said this in your contract, this trailer is going to be at 1234 Main Street, and the client says, I'm done with that, or I want to go move it to 78910 Main Street, you want to make sure that you've not limited in your contract that that's the location of it. And you probably you want to put something there, I would think, that if this contract moves with it to a new location, or the customer has a right with the consent of the security company to move it as long as notice has been given. Because what you don't want is it's on site A and it says it's on site A, they move to site B, and suddenly it's not saying that it's protecting what it's protecting or detecting what it's detecting. So you've got to be careful that your contracts properly describe the service and the location of what you're doing.
Sure. I would think too that you should, as a business owner, contact your insurance carrier and make sure that they understand what service that you're offering and that you have full coverage for that as well, because it is different. It is a different bird. And to your point, Mark, I think it's so important that you as business owners make sure that your contracts are very clear on the expectation of a service like this, because let's say you offer them full perimeter cameras, but they say, you know what, we're gated in the back, or we've got a chain link fence in the back, so we're only going to do cameras at the front. I would think that you need to be really specific that you chose not to put cameras in the back, so we are only offering this to cover this part of your geography. Does that make sense?
Absolutely. You've got to be very specific about what you're doing in this area. Because if you say, I'm just going to provide a camera at 1234 Main Street, well, where? What are you watching? Where are you going to be? Where are your cameras going to be if you're installing cameras around a site? You've got to be super careful. And your point on insurance, Kelly, is huge. You want to make sure that your insurance carrier knows what you're doing, especially in these new technologies, because you don't want them to say, well, I quoted the policy knowing that you were going to do fire inspections, and suddenly you're doing these 16 different things. Your premium may go up, may not, but you want to make sure that they know exactly what type of services you're providing, especially in your errors and omissions coverage.
Yeah. Talk about that a little bit. We talk about the different things in the contract. We talk about, things that indemnifications and different pieces of the contract that tie into insurance, and how those things work in accordance with one another. Can you just speak to how those work? Like, you talked a little bit about third-party indemnification and limits of liability and how that's changing. would you just dig into that a little bit more? And then I've got a story. Actually, Mark, you know this story, but I wanted to share a quick story about limits of liability. But first, will you just kind of talk about how those all tie in?
Sure. Yeah, they need to be fair. I mean, what we're seeing now is anything from $250 to $1,000 in your limit of liability. And what you've got to be careful with insurance is a lot of times, especially office management companies or real estate management companies that do multi-tenants, they'll say, well, you need to name us an additional insured. An additional insured is fine. But what I'd like to add to that is we'll name you additional insured for acts of our employees while we're on the premises, not for alarm events. So if your technician is up on a ladder and they drop a hammer and they hit Mabel in the head and she's hurt, yeah, you're on the hook for that. But your technician's up on a ladder and he's not watching what he's doing and he misinstalls a smoke or a fire and the building burns down, you don't want them to be an additional insured because then they have full insurance coverage on your policy, just like you would be able to make a claim on that policy. And you can't say, no, we're not offering that to you. And these management companies, somebody went to a seminar one day and they told them you should make all of your vendors additional insureds. Well, there's a big difference when installing a security system or an access system than hanging drywall. And the risks are much higher. So you've got to be really focused on what you're offering in there. So think about it when you're asked for an additional insured. You certainly can and do it, but sometimes it gets a little dicey. And just as an aside, and Kelly and I talked about this, I should have said at the beginning, these are my opinions. I'm not giving you legal advice. And I need to put that out there because I'm telling you what I think, but not advising you on a specific subject.
All right. I'm going to just tell a really quick story about a contract.
And then I'll match you on it.
Okay. All right. So I had a company that was selling. This was well, it was actually 2 years ago now because we are now a year past their sale. And when I started working with them, they were about ready to sell. They had around 85,000 of recurring monthly revenue. It was a mixture of commercial and residential accounts. They had the year before had a new contract created and signed all their customers to a new contract. So one of the first things that I asked for is a copy of their contract. I look for general things, and then if there are things that I'm not sure about, I would send it to Mark or whoever the attorney was and make sure that they're reviewing it. But before I do that, I've looked at tens of thousands of contracts over the years, and this one in particular, they sent it to me and I looked at it, and their limits of liability was $250,000. There was a typo in their contract that they did not catch. All of their customers had signed the new contract. Who wouldn't? Your limits of liability are $250,000. Well, the problem is no buyer is going to buy a contract with that limit of liability. We had to go through a complete re-sign again, and their customers had just done it. So they were feeling not great about it, and it took them over a year to do it. So little things, that little decimal point with the 2 extra zeros on it just killed them. So anyway, Mark,
And I have two. Yeah, and I have two. One was very early in my career. I was doing due diligence, and for those who haven't been through a buy or a sell, it's as I've said in talking to Kelly, it's like a colonoscopy on a bad day. You're going to be taught. You're going to be asked everything and anything about your company, and you're going to feel that it's invasive, but if you're going to sell your company or buy a company, you've just got to get over it. And I don't mean to sound trite when I say that. And we were out doing due diligence, and it was before virtual data rooms, which are how you do it now. And we were on site. I'm reading I'm reading a contract, and I stopped and I looked, and all of a sudden it said ADT in it, and I went, What's ADT doing in this contract? And when I looked, they had borrowed an ADT contract to use for their contract, which is great. Everybody borrows everything else in this industry, and I'm not chastising for that. However, they didn't proof it when it went to the printer. And instead of saying their company name or company, it said ADT and they didn't catch it. They had to go through and fix all of those. The second story I've got, and it's in the assignment area that I touched on briefly before, we had a client who was selling their contracts, and they must have had close to 1,000 contracts. And in their contract, it said that the alarm company could not assign the contract without the consent of the customer. And it's same as in Kelly's story, it took close to a year, and this company had to go back and re-sign all 1,000 contracts to be able to sell them to a buyer. And so it goes back to sort of where I started. Make sure you've read your contract. Make sure you know what's in your contract. Make sure you understand it and understand the issues that could be there. And the last on the limitation of liability is we represented, again, another seller who was in a major metropolitan area and had installed fire alarm systems in hotels. And these were 40-story hotels or more. And in order to get it, they said to the client, okay, your limit of liability instead of $1,000 needs to be your insurance coverage. So suddenly, if you're carrying a 1 million, 2 million general liability E&O, you've now given them $1 million. And so then you go to a buyer, and the buyers oftentimes are larger. So they're carrying $10 million of general liability and E&O coverage. Suddenly, this client now has a $10 million limit of liability. So think about before you offer things like that, because it could have a negative impact, because this same client went out and instead of a third-party indemnity where the alarm company was being indemnified by the customer flipped it and said, no, alarm company, you're going to indemnify us for any claims. So take this same fire scenario, people in a hotel, fire alarm goes off, even if there's no fire, people get hurt going down the stairs, they would be on the hook. So it took a lot of convincing to make this deal work.
Yeah, for sure. So a couple of more questions. Who can sign the contract? And this is one of those things too. You want to make sure you're always doing your own contract diligence. So somebody in your organization needs to have signed the contract, and that signed copy should be in the hands of the customer. But Mark, who should be authorized to sign contracts? Can a sales rep sign a contract?
Great question. And it can go either way. If you are comfortable with your sales reps, and it depends how large your organization may be, great. You can have one line on there, sales rep signs it, customer signs it, you're off and running. Are others where people are saying, I want to make sure they're pricing it right. I want to make sure they're offering the right things. And there's a separate line underneath, pardon me, that says manager or owner or president or something. And it says generally above it, this contract is not effective until signed by an officer of the corporation. So it's got to come back in. It's got to come to somebody who's got the authority to sign, approve it, say, yep, let's move forward. So you've got to build in that process so it doesn't slow you down because you want to get these systems installed, but at the same time, you want to make sure they're fully executed. Because if you don't, if there's a line there and it's not signed, you technically don't have an effective contract. And I've had clients have to go back and then re-sign, which is not A, a fun thing to do. B, it probably is not effective because it wasn't signed at that time. So if you're going to sell and suddenly you've never signed it, but you've got this line in there because you copied the contract for somebody else, it can get a little dicey. So know how you want your contracts to be signed, who's got the authority to bind the company.
What about people that would like to go to an electronic contract or have their contracts stored electronically? What is your advice
More
on
and more, yeah, more and more companies are going to electronic contracts and using DocuSign for signatures or something similar. There are vendors out there now. One that we've seen very recently in the alarm industry that you can do your signed contracts through them, and then they do what's called vaulting. And we're seeing vaulting more and more from a protection standpoint from lenders in the industry, And the reason for this is basically they take that contract, they have all of the certifications that it was a validly signed contract, and then they put it in an electronic vault. And what that does is if you default, if you're the alarm company and you default on your bank loan, then then the banks can actually take over the contracts physically, and they can then go sell it. And I think more and more banks are asking for that, and more alarm companies are thinking about doing it just as a protection. Because if you're still using paper contracts, you've got to make sure how you're protecting them. I would always recommend a fireproof, say, a fireproof cabinet in a locked room, because you don't want them walking out of there. And you really should have what I'd call, and you may have seen these sign out cards in the file drawer. So if I'm going to go pull Kelly Bond's contract because I want to look at it, I put a card in there that said, okay, Mark Katz has Kelly Bond's contract on November 9th. And that way you always know where your contracts are, because you don't want them walking out of the building.
It's like when you used to check out a book from the library.
No
You got
different.
on the card. Yeah. No, I love that. And I think, were you referring to Loiva,
That's
Loyva?
precisely,
Yeah. So
I've talked
definitely,
to them, and
yeah.
I mean, I have not used them yet, but I have talked to them and it looks like their product's an awesome product.
Yeah, I was thinking the same thing. So anybody that wants to know, we have no association with them at all, but they are new to the industry and I love what they're doing. It's Loyva. So you can just Google that and I'm sure you can find them.
Yep.
Um, let's talk about non-standard contracts, because this comes up a lot in diligence, and typically it is a schedule in a closing. A schedule is a supporting document to a purchase agreement, and it's usually in the form of reports or copies of things. But these non-standard contracts come up, gosh, every single transaction this comes up.
Yeah.
So what can you talk about that a
Yeah.
little bit?
Yeah, they've got to be disclosed. Anything that's not on your standard form, or where you've made what I'll call a material change to your standard form. Material change is crossing out the limit of liability, putting in insurance, as we just talked about, instead of $1,000. But the non-standards are, you get a customer, you get a large customer, and the customer says, well, that's really nice, but you're going to sign our contract, Mr. Security Company. Well, the problem is that's the same contract, and I sort of mentioned it before, is as if they're hanging doors or hanging drywall. And so it's going to shift the burden to you, the alarm company or the security company, with respect to those obligations. The indemnity, there won't be a limit of liability, the additional insured, things will be in those contracts. So make sure you've read them. If you're willing to accept that and your insurance company is willing to accept that, more power to you. But understand what you're signing, because you may be giving away more than you're comfortable giving away. And you can always blame your insurance company. I can't do this because my insurance company won't let me, or my lender won't let me do this. But you really need to understand what's in there, and if you're willing to take that issue. Government contract, and you've got to disclose anything that's non-standard. So if you regularly enter into non-standard contracts, and you're going to see that more in an integration business than in a typical monitoring business, make sure you understand who you're giving those contracts to. Is it, Procter and Gamble, because they're a huge company, and if you want to do business with P&G, you're going to sign their contract? Or is it Joe's Bar and Grill and somebody gave Joe a contract? I mean, it's big difference, and should you accept it or not accept it? The other one is government contracts that you'd have to disclose. If you're going to do business with the government, you're not going to be able to say, I want to make changes. Bottom line. And I'm using government fairly broadly, not just federal government, but there's state, there's local, there's schools, there's fire departments, there's city halls. All of that is considered government contracts. And in any acquisition, they're going to want to know who your government contracts are, because a lot of times two things pop in a government contract: the assignment clause, where you need permission to assign. And if it's there, the buyer may say, I want to do this before closing, or some buyers may say, I want to do this after closing, but it's subject to. The other is something called prevailing wage. And I'm dealing with this right now on a deal where prevailing wage is where government money is used for a job. And they say, if you're normally paying your techs $20 an hour, on this job, you need to pay them $30 an hour, plus benefits equaling a certain dollar amount. And that's not negotiable. If it's federal money and they indicate on it prevailing wage, you must do that. And I've been involved over the years with cases where that wasn't done, and it's really ugly to unscramble when it comes to prevailing wage. And there's some buyers who won't do it. I've got a deal right now where there are 5 or 6 of them. The buyer's saying, I'm not going to take them. So now we're trying to figure out, okay, what are we going to do with these contracts? How are we going to not have our client in breach of those contracts, but still sell the business? So that is one area you've got to be cognizant. The other one, be cognizant with the government, is small business, women-owned business set-asides. More and more large companies are coming into our industry, which is fantastic, many of which are owned by private equity. And if you have a small business set aside where money was allocated that way by the government, or a woman-owned business because a woman owns more than 50% of the company, and you've done the forms to accept these. Some of these larger companies can't accept those because they are not either woman-owned or a small business. So you've got to be very, very sensitive to that as well. It's great. It's a wonderful program. But if you're thinking about selling, you've got to at least keep that in mind. And how many of them do you have? If you have 1 or 2, you can deal with it. But if you really go after that, and some people do, which is fantastic, just got to be sensitive of in this case, Kelly would have a more limited list of who she could go to.
Yep, absolutely. It does. It definitely makes the pool of buyers smaller for sure. But the benefits that you get today from those designations
Are great.
versus what you do later, it may fully pay off. So certainly not discouraging those
Nope.
designations, but just know on the back end, it may make your sales process a little bit longer. But again, there's still buyers out there for it. So
There's still buyers. You just have to be sensitive of understanding what those limitations are.
yeah. Mark, kind of talking on this, and I know this is not a non-standard well, because it's not a contract necessarily, but I'd like you to talk about POs. What if the end user presents a PO to the business and that's all they're willing to sign? Everything is in that PO, and there are no limits of liability or third-party indemnification. Well, the dealer is certainly indemnifying the customer, but it's not the other way around. So what do you recommend? And listen, in the integration world, this happens every day.
Every day.
How do they protect themselves?
I really think what you have to do is look at what's on the PO, no different than a non-standard contract. Consider it in your head, it's a non-standard contract. And look at what you're agreeing to give to that client in those terms. It may not be on the front. Remember to turn them over. If a customer sends you a PO and only sends you the front, please ask them, is there a reverse side to this PO? Are there terms and conditions? The other thing we're starting to see with POs is it's just a front, but it references, go to this website and here are our terms and conditions that are incorporated by reference that you're agreeing to. Take the time to go to that so you understand what you're agreeing to. In many cases, you're not going to change it. And oftentimes with non-standard contracts and POs, clients will say, well, I attached my contract to it too as an exhibit. And that's fine, but where it gets a little bit dicey is you end up with a battle of the forms. And what I mean by that is you then have 2 forms, your contract and the PO, or your contract and the customer's contract, and there are things in them that conflict. What's the winner? Which one prevails? And sometimes customer contracts will say, if you attach anything, ours prevails. So again, the most important part is knowing what you can change, if you can change, and understanding what you're agreeing to. POs in the integration business are, as Kelly said, enormously common, and buyers will take them. But again, you've got to be able to discuss it with a buyer, or if you're a buyer, you've got to discuss the sellers and understand what you're agreeing to.
So I'm going to change lanes a little bit because I want us to have a few minutes to talk about licensing. Because all of this, it all ties in, of course. And the license part of it, I think, has become more of a question as we have less of a chasm between alarm companies and integrators. There's a lot more mix. Thankfully, I'm so happy to see this in our industry. But then becomes the question of who needs a low voltage license? If you're installing access control, what do you need? What if you're only putting in cameras? Can you just give us kind of a broad view? Also, fire. Listen, we all know fire. Yeah, you better be licensed, and there are different levels of licensing that you have to have. And perhaps you have a license holder in your business that's qualifying you. But can you just give us a broad overview of licensing? And then I'll plug some questions in a minute.
Sure. I think, and I'm going to sound like a lawyer when I say this, and I don't mean to, it depends. And the reason it depends on the state. Every state and local locale are different. Some states require multiple licenses, some states are stricter. I believe that Texas, California, Florida are some of the strictest states that are out there on licensing. And they're very careful of who they approve and what they approve it for. So in Florida, had a situation a year or two ago where um, the acquiring company we were representing was acquiring somebody who was an electrical license. And for some of the stuff that the seller was doing, you needed an electrician license. They already had their alarm license, so that was no big deal. And they went to go transfer it, and they said, "Oh, you needed to do this before you closed. You needed to have this license in place." And they spent a great deal of money with local licensing council to try and get it through the system. Texas is an example where you have the Board of Private Investigators and the fire marshal, and you need to be licensed there, and your employees need to be licensed. Illinois, every employee needs to have what's called a perk card if you're going to be in the alarm industry. So most things do require it, and you've got to be really, really careful to determine what licenses you need to do what you're doing in your business. And where you've got to be careful is if you add services that might not otherwise be under license A, but they're under license B, go get that license. Don't wait. And don't wait till you started selling that before you go get the license. It is a whole lot easier to go get licensed, find your qualifying manager or your QA, and get it on the front end rather than the back end. And if you're going into a new market, you've got to make sure that you have a QA, or a QM, a qualifying manager, because so many of those licenses, in addition to the company being licensed, the individual has to be licensed. And so you oftentimes enter into an agreement with a seller that the seller, for a period of time for a fee, stays as your license holder until you can get another full-time employee up and running. Got to be careful because the QA or the license holder, the individual, could have liability, and so you want to make sure that they're properly protected by the company.
It is very important. We run into issues all the time with who the proper license holder is. But let's make it even a little more gray, potentially. I mean, what you said is certainly black and white. You do have to look at what the state requirements are, and hopefully you're doing it anyway. But let's talk about if you're using subcontractors and maybe they're in a different state. What do you need? You as a business owner are agreeing, I'm going to work with this sub. They're going to do my install for me. I'm keeping the recurring revenue. What do I need to do to make sure that I am covered by having that sub work on that job?
Couple of things. You need to make sure that the sub is licensed if licensing is requiring that state. You need the sub in your contract with the sub to reaffirm to you that they are qualified as a fire installer, as a alarm license holder, whatever it is in that state. You need to go look and see what the rules are, because if you're just, and Kelly and I just went through this 2 weeks ago, we had a client who was shipping product into other states, And when they were shipping things onto those states, interstate commerce probably was allowing them not to have to do it. But where it gets dicey is if you're monitoring from that state, some states say that monitoring requires you to have a license in that state. I think Tennessee is one of those where that we've looked at in the past, where if even if you're using a sub, if money is being paid to you outside of the state of Tennessee, you need to have a license in Tennessee in order to do the monitoring. Sometimes you can get around that because the monitoring centers, thank goodness, have all the, for the most part, have all of the licenses that they need in order to do monitoring on the major ones. But you need to make sure if you are using a monitoring center and you're going to say, okay, I'm going to be covered by my monitoring center, make sure you ask them, are you licensed in Oklahoma? Are you licensed in, if that's where you're going to go, to make sure that you don't get inadvertently caught on something like that?
Yeah, it definitely is a state to state thing, but you think about national companies like ADT and Brinks, and they are licensed in every single state that they
Yeah.
are doing any business in. Most states do require it, not necessarily like the example that you gave and the client that we closed a couple weeks ago. They weren't doing monitoring. That was they were just installing camera systems with a NVR. So they were okay, but then that brought up the which you touched on just a little bit, a real big tax question. Thankfully, it was one client. They were only doing business for one client, but that happens all the time, and it can be multiple clients, especially if you live on a border. You got to make sure you're in compliance.
And in that case, the client said, look, we're not paying sales tax. The customer is going to pay the sales tax. And the customer agreed to pay the sales tax in multiple states. Well, the problem is that's really nice that the customer wanted to do that, but that's not what the law says. And so it delayed our closing by 6 weeks at least because we were trying to figure out and working with other professionals, what did we need to do? What was the comfort level of the buyer that this customer was paying for it? And no state wants to get paid twice for sales tax. But you need to know if you're shipping in the other state and there's a sales tax requirement, 90% of the time or more, you're on the hook for it. And you need to charge the customer and you need to file the appropriate sales tax returns. And what some clients have done incorrectly is they're located in state A, they're going to state B. They say, well, I paid the sales tax to my home state. Doesn't work that way. And there are income taxes depending on the structure of your company. Sometimes if you're a non-resident, that comes in. And then the other piece you got to think about is qualification to do business. And from just a 30-second thing here is if you are going into the state and you are more than just, oh, gee, I have one account that they pay me $50 for, you may not need to be qualified to do business in that state. But if you're doing, and the guide is, it's not 100%, but if you're doing $100,000 a year worth of business or more, that's a good guide that you need to be qualified. And what that means is you take your corporation or your LLC from your home state and you qualify it as a foreign corporation, not meaning foreign internationally, meaning just another state, and qualify that entity in the new state. Because you are required to do that if you're transacting business. And if you don't, and the state finds out, or if you go to sell and the buyer says, well, you have $500,000 worth of business in state X, you need to qualify, there can be penalties and interest.
Well, believe it or not, Mark, we are out of time.
Yep.
And I'm going to wrap us up right quick. Well, I may have to get through some slides. It's going right to the beginning. So, okay, you heard me say this. If you were on any of the other webinars, run your business today like you're selling tomorrow. All of the information we've been giving you in these webinars is to help you do that. Make sure you are seller ready. If you have any questions for Mark or for me that you did not think of while we were on this call, please let us know. You can send them to Chelsea. She will make sure that either of us get them, and we'll try to get back to you with a response. I want to make sure to let you know that our very last webinar in the series is 2 weeks from now, where we're going to be talking about strategies for profitable growth. I believe that Alibi has already sent out a registration for that, so make sure you register when you can. Here is my contact information. If for any reason, and I'm sorry, Mark, I did not get your contact information on there, but if anyone wants Mark's contact information, please feel free to email me or email Chelsea. As you already heard, I highly recommend that Mark and his firm. Mark, thank you so much for taking the time with us today. I can't believe how fast that went. I looked
It went
at the
really
clock and
quick.
we're out of time, but thank you so much. Your information is just absolutely invaluable to business owners, and I just appreciate you. Thanks so
My
much,
pleasure.
everyone, and that's a wrap.